A very good evening to distinguished panelists, our most valued, enthusiastic students, and my worthy colleagues. It gives me immense joy to welcome you all to the webinar on subject orientation for overview of optional subjects for LLB fifth term. This webinar aims to examine, evaluate, and address the contemporary relevance of the subjects offered at Law Center 1 so as to enable the students to take a reasoned, rational decision. I extend a warm welcome to all of you for making time to attend the seminar. May we all leave more enriched and enlightened. I now invite Ms. Archana Mishra to please deliver her welcome address. Over to you, ma'am.
Good afternoon, all faculties and dear students. I welcome you all to this webinar on optional papers for the fifth semester. I congratulate all second year students to have been promoted to the third year, the last year of their legal studies, and is the most important year also of legal studies because this is the time when they can fill in all the gaps that had been left in their first and the second year to fulfill all the deficiencies that were left in those years. So I, Archana Mishra, am going to tell you about all the optional papers that is available in the fifth semester or the third year. But before getting into the optional papers, I'd like to inform you that there are 3 compulsory papers and you have to study only 2 optional papers out of 7 available optional papers. Out of those 3 compulsory papers are drafting, pleading and conveyancing. Drafting, pleading and conveyancing is a practical compulsory paper. Since drafting means the art of writing, so for a legal professional, the art of legal writing is a must, be it any kind of drafting. This particular paper gives a knowledge or makes the student be aware of how to draft a good paper, be it the civil pleading, be it the criminal pleading, be it the matrimonial pleading, any of those. So the students are going to be taught how to write a good pleading. The next important paper is the moot court. That is another practical paper. This paper aims to impart practical skills of case analysis, research as well as witness handling, argument presentation. So the students are going to learn all these aspects in their moot court. This moot court paper is divided into 4 different parts. The first part is the moot court itself. The second part is the mock trial. The third part is court visits, and the fourth one is the viva voce. The last compulsory paper is industrial law. So the students would be made aware of what are the disputes, how are the disputes being settled under the Industrial Disputes Act. Not only it's about the dispute settlement, but it's also about awards that are there under the Industrial Dispute Act and all the relevant acts which are related to industrial disputes. Then I'll move on to the optional papers that are available for the fifth semester. Out of 7 optional papers available, the students are to choose only 2 of them. The students are required to choose any of the 2 optional papers very, very wisely. So you need to listen all these experts who have come in to discuss about the syllabus as well as the scope of their respective paper. The first paper, as I said, there are 7 optional papers. The first optional paper is Jurisprudence 2. Dr. Meena Panikar would be elaborating upon it. She will be giving you an overview of the syllabus as well as the scope of that particular paper. Then we have Criminology, for which we have Dr. Avekta Verma. She will be telling you about the syllabus and the scope. The third optional paper is IPR2, Intellectual Property Rights, for which Dr. L. Kumar is there to elaborate on it. The fourth is Rent Control and Slum Clearance. We have Dr. Anju Sinha to give an overview of that paper. Then the fifth optional paper is Business Regulation. Dr. Praveen is there to give you an insight of that particular paper and the scope of that paper. Then the sixth important paper is International Trade Law, dealing with all the international laws and the different treaties, the conventions, for which we have Dr. Gurpreet Singh. The last paper is Information Technology Law, for which we have Mr. Anil Sai to give you an overview of the entire syllabus. Now I invite, but before inviting Professor Meena Panikar for Jurisprudence 2, I would like to make certain things noted to the students, that every student is for every student is compulsory to fill in the optional form that will be available in a day or two after this webinar is over. Every student is required to fill the optional form. That is, as I said, it will be available online in a day or two. The last day for applying is by 27th. So every student is required to fill in the form before or by 27th of June. And after this, even if the student has any doubt, any problem in understanding what is the scope, what is the syllabus of any particular paper, they can get back to any of the faculties, or can also go through the case materials that are available online. So now I'll hand over to Professor Meena Panikar to introduce her paper, Jurisprudence 2. Thank you.
Yeah, thank you, Archana. I hope I can begin with my discussion on the paper. It's Jurisprudence 2, and I hope, as Archana said, let people have their wisdom to choose the optionals. Uh, you had already a Jurisprudence 1 paper in the first year. I hope you have been very basically introduced into the subject, which the predecessor of which was known in law faculty as Introduction to the Indian Legal System. So now they have renamed it as Jurisprudence with a little bit of changes in the syllabus. Followed by that discussion is Jurisprudence 2, which is an optional paper. Now, I just take you through some of the objectives, which are not very market-oriented objectives. But I just would say that when you start reading the paper, and then in the end of the semester, we hope that you will understand the foundations of laws which are in operation in the country, and the legal system, how the legal system itself is being based on. It introduces you to the works of different thinkers from different parts of the world, including from India, about their understanding about the foundations of this legal system. And the third objective is to see how the laws operate in a given society. Now, all these three objectives may look very abstract to you at present, but in the end of the course, what I have seen is that the students have done much better than what apprehensions they had in the beginning of the course. So it may look like very theoretical, but you can see that it's a mix of both. 50% of the syllabus is based on theoretical, the juristic basis or philosophical basis of law, but the 50% is on the way it operates in a given society. So that takes you through the broad topics which have been included in the syllabus for discussion. One is on the concept of rights and duties, the jurisprudential basis, and the second is on the philosophical analysis of concept of rights and duties. And the third is generally on liability, and fourth is on personality, and fifth is on property, and the last one is on possession and ownership. So if you look at the first two topics that are centered around jurisprudential and philosophical foundations, but the rest are about how the laws therefore operate in a given society in terms of fixing liability, identifying the legal persons, then the issues in relation to property transactions, and the possession and ownership. Now, if you look at the first topic, the concept of rights and duties and jurisprudential analysis, what has been done is to introduce you to the writings of a few thinkers, including the names of R.W.L. Dice. Then you have H.L.A. Hart, Wesley Hofield, and the Indian authors Chhatrapati Singh and Professor Ubendra Bakshi. So all these discussions, as far as topic 1 is concerned, are centered around Hofieldian diagram on rights and duties, which you may have an understanding. And further, including the writing of Hofield himself, its critical analysis by many others, including Professor Chhatrapati Singh in the Indian context, how that Hofieldian diagram may not be exactly fixing in the scale of distribution within India, and Professor Ubendra Bakshi's analysis on how the constitutional scheme is looking at the Hofield's scheme of rights and duties. Now, if you look at the second topic on rights and duties, the philosophical analysis, we take you from the realm of law to other social sciences and introduce you to a set of scholars like Professor Bikhu Parikh, Alan Buchanan, Ronald Dworkin, and Amartya Sen. So you will see that the whole scheme of articles which have been included in topic number 2 are discussing about the philosophy, more about the philosophy of rights, but not necessarily by the pure legal scholars, but by the social scientists from different streams. So that gives you a very, very different perspective about the foundations of the concept of rights. Now, if you look at the third topic, which takes you through the operationalization of law, it speaks about liability, where we take you through the traditional readings of Fitzgerald, and discussions are centered around fixing civil and criminal liability and how administration of justice is secured within a given society. Here again, you will see that justice has different connotations. So the discussion will not be necessarily limited to the discussion on justice as administered only through the courtrooms. Now, you also will see that the other topics, property and possession and ownership. If you look at property, there is one topic which is missed in between, that is personality. Now, personality may be a very traditional topic, identifying legal persons in a given society, which is relevant both in international law and national legal systems. It's about who are the subjects of a legal system on whom a personality is conferred by law, as a benefit of which the person may have a right to sue and be sued, enter into legal transactions, establish relationships, enter into agreements, etc. And the right to acquire and dispose of property. All these are characteristics flowing from identifying an entity as a legal person. So we first introduce you to the set of writings of scholars of Joel Hinberg, R.W.M. Dice, and Burley and Gardiner Means about the theoretical basis of conferring a legal personality, wherein you will come across the discussions as to why we need to have a legal personality, and the discussions as far as natural persons are concerned. The things may not be much more difficult, but the complications come in as the discussion proceeds and identify more entities as legal persons, for instance, unborn persons, corporations, etc. Now, there is a larger discussions on certain entities like corporations. Lot of discussions have happened about unborn persons. So all these are discussed in the papers which have been given to you. We also rely on a lot of case laws, which have, particularly from the Indian context, discussing about legal personality. Now, from last year, what I have done is to look at the latest developments in legal personality, particularly about the Hindu idol as a legal person, the rivers as legal persons, basically relying on the judgments of Uttarakhand High Court, the Sabrimala judgment and the Ayodhya judgment, which also raises issues as to whether identifying a legal person is enough and how far a legal person can claim fundamental rights in the given constitution. You also see the discussions on property in the next topic, where we introduce you to the writings of renowned scholars like Roscoe Pound, Jeremy Waldron, John Locke, Confreud, and the Law Commission of India's report. So property discussion is speaking more about the transfer of property laws. Then you have the possession and ownership, which also partly flows from the property discussion, where again we discuss case laws and the writings of Fitzgerald, Honor, and Lalanji Gopal, particularly about the property discussion in the ancient Indian context. So this is the broad way of looking at jurisprudence too. So you can see that it's a mix of the legal philosophy and the case laws which have been built in India over the years up to the present day period. So that's all about jurisprudence too. My only advice to students is that this will allow you to, like Archana said about drafting and pleading, how well versed you should be in your drafting. Uh, I would just add on to say that drafting also requires communicating an idea and its interpretation to help resolve a legal issue. And therefore, this kind of a foundation in jurisprudence will actually help you to go a long way in the building up of your arguments and the writing skill in general. Thank you.
Thank you, ma'am. And it was really enlightening to listen from you. And now I would request Dr. Avekta Verma to enlighten the students on the prospects of criminology.
Hello, everyone. Can you hear me?
Yeah, we can.
Okay.
Yes, ma'am.
Okay, fine. So I will be giving an overview of criminology to the students so that it helps them in choosing their optional subjects. So now, when we talk about criminology, I feel all of us have thoughts about crime and do discuss everyday's happenings as it comes in the TV, newspaper, that this particular crime has taken place, and we do all of us do give our own opinions about what should happen. And but when we talk of criminology, it's not just our moral opinion about yes, the person should be punished or this should happen to the criminal. Basically, a scientific study of crime and criminals, and it studies crime in all its aspects, in the sense as to why crime takes place, why certain people commit crime, and if crime has happened, then how the society should be reacting towards it, and then why in certain places, environment, at certain times only the crime happens, and does the race, gender, culture has anything to do with the commission of the crime in the society. This is all in a scientific manner, not simply giving one's own opinion. And when we study it with the help of different thinkers, school of thoughts, what they had to say about the existence of crime, the recognition of crime, because all these questions come as to, even when we say crime has happened, then why is it that a particular crime only is recognized as a criminal activity and not the other one? So, this is basically, you can say, a very fascinating, a very interesting subject, and it is so also because of the fact that it deals with the real people, and the crimes which are happening in the real
Hello.
world. Yes, hello.
Yeah, Shivika.
Yeah, I think I'm audible to all.
Yes,
Yeah.
ma'am, you're audible. I just have a request that when the presenter is making the presentation, others may kindly mute themselves so that the presentation is clear.
Okay,
So I just that request.
okay, fine. Okay, fine, fine, fine. So we just move ahead. So this was just a basic introduction about criminology, what all area it's deal with. When we look at it in a narrow sense, we see it as dealing with the causes of crime, etc., and what should be done about it. Now, when a student decides to choose this subject and takes up this course, how they are expected to go about it. They are supposed to have a very open mind, a very critical mind, because when they do read the readings which we provide them, then they need to have a questioning attitude, in the sense that they need to question the established, you can say, notions. And in the sense, if I give you an example, for example, in criminal law, we have these very two famous maxims. That is, when we talk about crime, there are two maxims, that is mala in se and mala prohibita. When we talk about mala in se, it means something which is intrinsically wrong, morally wrong. So it will be considered as wrong in all the societies, in all the countries in the world. Right? It has universal application. Mala prohibita is something which is done by the statute. And when you have read this maxim, mala in se, then we give the examples of murder, robbery, dacoity, rape, etc. But then when I'm saying you should have a critical mind, then you need not accept these maxims the way they have been explained as it is on its face value, because even when the examples are given of that of rape, murder, etc., which it seems that every country in the world, every society condemns it, that is not true if you delve deeper into it. Because even if we take the instance of rape, it is not that in all societies, in every circumstances, that particular act is recognized as such. Right? In some societies, male rape is recognized, in some it's not. Marital rape is recognized, in some it's not. So the variations, they always happen. So when we discuss or when you read criminology, it is with this critical bent of mind that you'll have to read it, and you have to be involved and engaged in the course, right? So that there can be a discussion in the class. And as you acquire this knowledge, it will stay with you for all your life. Because as criminologists, even your employability increases. In the sense, if I look at the career options in criminology, if you take it as a subject, then as an advocate, as a criminal lawyer, it is going to help you. As a judge, it is going to help you. Or you can be a policymaker, or you can join some police institutes, you can be a researcher, or in some universities, if you want to take the make academics as your career, then in some universities criminology is offered as a course, so that they have special teachers for criminology and penology. And you have to clear net exam for becoming a lecturer, and there is a separate exam for criminology. Net is there separately. So sometimes the posts are advertised only for criminology and penology. So there also you can apply. But otherwise, also as a stakeholder, this knowledge is going to stay with you for a longer time and you can contribute. So when you are reading this particular subject, side by side, if you do the internship with the juvenile justice homes, you visit that or other places, it will give you a practical aspect also, because this is something, a subject which is dealing with the real situations, and you can apply your knowledge, you can contribute, you can do research. So that will be your contribution. So when we look at the criminology in the narrow sense, it is dealing with all those what, why, when, the causes and the response, etc., to the crime. When we look at it in the broader sense, and we look at the things to be discussed in the course, so you will find there in your case material, we discuss penology, and we also discuss victimology. In penology, because in broader sense criminology includes it, penology we study the punishment and the similar methods of dealing with crime, right? What kind of punishments should be given, and what should be the approach when even the punishment is to be given. Should we have a reformative approach? Should we have you can say, rehabilitatory approach? Should we have a deterrent approach, right? Or there has to be a retribution or denunciation? What should be the approach followed by the criminal justice system? What are the corrective measures which need to be taken? So, how the prisoners are to be dealt with, the conditions in the prisons, what policies to be followed there. So, all those are in detail discussed in criminology. Then another topic you will be studying there is victimology. That is how the victim is treated in the criminal justice system. And it is because of many efforts of the criminologist and the victimologist that now you can say even in India, the CRPC has been amended. The victim has been given a little say in CRPC now after the amendment. And so, how far you can say the victim can take part in the criminal justice process. So, that all, and in what ways and manners they can be compensated, or in what aspects we can have restorative justice. So, all that is discussed in victimology. So when you take up this course, it's very challenging, it's very exciting, it's very fascinating. And if you're just looking at it from the perspective of how well one scores in this subject, if you write well, you score good marks too. But then it is very important that you do your readings and you actively participate in the discussions and relate as far as possible to the real life situations, to the way our criminal justice system is functioning. So it's not all about theories, thinkers, and all. It's all about even the judgments given by the court, because even the way we see the criminal justice system today in India as well as the whole world, it is the contribution of the criminologist that the changes have happened and the reforms have taken place, right? So I hope many of you will be, you can say, opting for the course and making your own contributions. Thank you so much.
Thank you, ma'am, for those enlightening words. I'm sure there were many takeaways for the students. And now I would request Dr. L. Pushpakumar to please kindly enlighten the students on intellectual property law so that they will decide whether to choose it as an option or not. Sir, over to you now.
Thank you. Good afternoon.
Good afternoon, sir.
Yes. So is it audible well?
Indeed, sir, you are. Please go ahead.
Great. Yeah. Thank you very much. Thank you very much. Good afternoon to all the students. I'm going to introduce the subject Intellectual Property Law 2. Most of you would have studied Intellectual Property 1 in the last semester. You would have studied the concept of intellectual property, the trademarks, geographical indications, and industrial designs law. So these are the units or the topics that you would have studied in Intellectual Property 1. And now in Intellectual Property 2 in this semester, we are going to cover the other aspects of intellectual property. Before going to that, I would like to tell you, sometimes, I encounter a question from, students that, they have not studied IP1. So is it possible for them to opt for, IP2 now? Perfectly, you can do that. It is well and good that if you have studied IPR1 and also IPR2, so it will be very good for you that you will have a complete knowledge of intellectual property. But sometimes you have not chosen IPR1. It is still perfect. If you have now developed interest in IP, you can still take IP2. So there is no problem. You will still pick up. And it is not that, only when you study IP1, you can take IP2. So I think, this doubt, I think, I should make it very clear now. What we are going to study in IPR2? Here, we are going to study very important aspects of IP. There are different types of IPR you might have read in the last semester. We call it different forms of IP, in fact. In this semester, you are going to study copyrights, patents, plant variety protection and farmers' rights, traditional knowledge and folklore, including the traditional cultural rights, and protection of integrated circuits. So these are the topics that now you're going to study here. I'll tell you a little bit about, the different topics that I have narrated. In copyright law, you will be exposed to the concept of copyright, what it is. It's very interesting to know that normally we say that, whenever you create something very, interestingly, a novel idea, a novel thing, so it gets copyright. It's not really true. It's not that the novel ideas are being protected under copyright. It has to be expressed for protection under the law. So it is not that the ideas are protected under, very excellent ideas, a very new, very interesting, creative ideas you get, and unless they are expressed in a form, a written form or some other medium, it is not protected under copyright law. So that kind of, the concept that we are going to introduce, we call it idea expression dichotomy. Okay, so only in the expression you get the copyright. So when, for example, we used to tell in the class, we'll be, explaining it with lots of cases, as well as, the experiences, that we encounter many times. For example, I take you to a restaurant and I tell you a nice story that I have conceived in my mind. It's a wonderful story. I'm telling you the plot of the story. I also tell you about the characters that I have in mind, and I'm telling you that I'm going to write it as a novel. And after our dinner, you go back, and before I could express in my book, you have written a novel. Who will have copyright on this? Whether you will have or I will have, because the story is mine, the idea is mine. Whether I will get copyright or you will get copyright. The law says that you will get copyright. It is not the idea that gets protected here, and it is the expression, who has given the expression to that idea, and you get copyright because the copyright is for the expression. Okay, there are many other things, if it can be, if I have given the idea in the form of a concept note, the concept note is in the form of writing, then I will get an protection. So like that, there are many interesting things that we are going to discuss in this subject. And in this subject, again, after understanding what is the subject matter of copyright, what can be protected as a copyright, what cannot be protected, all those things, once it is clarified, we will go into the rights part. What are the different kinds of rights the author gets in copyright? It's a bundle of rights, we used to say, different kinds of rights. For example, I have written a novel now, and that can be still made as a movie, or it can be written as a poem. It can be again reduced into a drama. So different kinds of, whenever it is expressed in different forms, you get different rights again. And it can be again published, republished. Reproduction rights are there. It can be adapted in different forms. So different kinds of rights, a bundle of rights you get under copyright. So all these things we'll be discussing with the help of very, very interesting cases. And also there are issues relating to who can be the owner of copyright. So once you know about the rights and who is going to enjoy these rights. So again, there are interesting areas where you will come to know that, for example, you ask me to take a photograph of you, or you engage me to draw a portrait of you. I have done that, and it is my expression, right? So I will have a copyright over your portrait, or you will have a copyright over your portrait. Or you engage me as a writer. So you are having a publishing industry, publishing company. You are asking me to write a report. I have written a report. I have done a research. I have written a report, and you have given me, a honorarium for that purpose. I have written it and submitted to you. Whether I will have a copyright or you will have a copyright as a company, because you commissioned me. These issues will be discussed. Very important, and very interesting too. So with the help of cases, very lively cases decided by the Supreme Court as well as the High Courts, we are going to discuss in this context. And like any other property, here the copyright can be assigned to somebody. It can be licensed to somebody. It's not that you will also, you will only have. So it can be, assigned or licensed to others with limitations or without limitations. So those aspects we'll be discussing. And also we will be discussing very important two aspects. One is about at what time or, it will become infringement. So if somebody is using your copyrighted material, so how the infringement action can be taken. And what are the exceptions to infringement? For example, some of you might have heard about the DU photocopy case. So when the copyrighted articles or the books are being photocopied and used for education purpose, is it still prohibited? Or is there any exception for the usage for the purpose of education or personal use or research purposes? So those aspects will be discussed in this context. Apart from copyright, we will have another important topic in this semester, that is patent law. So patent law is another important area where we protect the rights of the inventors. So it is not that all inventions can be protected under the patent law. The Patent Act says that which invention can be protected under this law. There may be any kind of invention, and that will also qualify for patent, but law recognizes certain inventions can be protected under law. So what are the inventions that can be protected under patent law, that we will be discussing. Then the procedure, what are the procedures you need to follow while filing the patent application. As we have discussed under the copyright, the patent can also be licensed. It can be assigned to somebody. And also the patentee, the patent holder, will have the rights, the specific rights they will have. What are the rights they will have? And if somebody breaches those rights, it becomes infringement. What kind of actions you can take in terms of the infringement of such rights? So these are the two segments now we are going to look at in the IP2. In addition to this, there are other important topics. They are very interesting to see. Intellectual property, as you have studied already, it gives you the exclusive economic rights, the monopoly rights for you. But sometimes that doesn't really fit into the domain of justice. Sometimes you feel that is it really right to give such right when the people are not able to access medicines, when the people are not able to access the educational materials, can you still strictly impose the intellectual property rights? So those such things are also going to be discussed in this subject. Just related to that, there are two topics that you will come to know. One about the protection of plant varieties and farmers' rights. There have been movement around the world that we need to protect the breeders' rights, and it has been protected internationally as well as nationally. Protection of the breeders' rights. When we protect the new plant varieties, the new seeds are being developed, and those seed developing companies, they will have the breeders' rights. And there are many socio-legal issues into this, because when the farmers, when they are compelled to buy the seeds every time, so what kind of rights they should have? Conventionally, they are not borrowing, they are not buying in the market. They save it, they share it, they resow the seeds. So are those rights protected? Yes. So those parts will be discussed in the Protection of Plant Varieties and Farmers' Rights Act. And also the traditional knowledge aspect. There is a long-standing question, going on around the world, that what kind of a protection we need to give for protecting the traditional knowledge and the traditional cultural expressions of the local communities and the indigenous communities. And they have been using this knowledge for several purposes. And this is for generations they have been using it. So when we say that, certain things that today, when I invent or when I create, that is a subject matter of intellectual property, And this is a community that this has been using such a particular closed knowledge for many years. Is it not about a subject matter of intellectual property? So that is one aspect that we need to look at. And there are certain negative protections and positive protections being discussed in the international arena, and that we are going to look at in this subject as the protection of intellectual, the traditional knowledge and the folklore and the traditional cultural expressions. And there are two more aspects we are going to look at. One is the confidential information and the trade secrets law. So this is again very important aspects recognized under the TRIPS agreement. The confidential information like the recipes or the formula for making certain the products in the market, and that requires, if that is not protected under copyright or the other forms of intellectual property, then if it is just a secret protected by a company or somebody, then what kind of protection we need to have? It's called the undisclosed information or confidential information or trade secret law, that we are going to look at how this is protected under IP. And also there is a special law for protection of the integrated circuits, the Semiconductor and Integrated Circuits Act, that we are going to look at how they are protected. So this is I think the wide range of topics that we are going to look at and discuss in Intellectual Property 2. I hope you will enjoy this. If you have any questions, you can always come back. Thank you very much. Shivika?
Yes, sir. Thank you so much, sir.
Yes. Was it audible and clear?
Yes, sir. You were very much audible and clear. And sir, it was really great to hear your thought-provoking ideas, from protection of creativity in the form of patents and copyrights to protection of identity in the form of preventing unscrupulous use of traditional knowledge. Thank you for that, sir. I would now call upon Dr. Anju Sinha to discuss a very relevant issue for now, rent, wherein we are debating the rights of tenants and landlords again in the present times. I now request Dr. Anju Sinha to throw light on rent control and slum clearance. Ma'am, over to you.
Yeah, thank you, Shivika. Very good afternoon to all of you. I believe I am audible.
Indeed, ma'am, you are. Please go ahead.
So, thank you, Shivika. I am here to give an overview over the subject of rent control and slum clearance. Now, before giving an overview about the subject, let me tell you the two main benefits of opting this subject. This subject is really, if you are opting this subject, it will help you both in the field of litigation, and also if you are intending to join the bar and bench in both cases. Like if you are intending to appear in competitive exams, in that scenario also, this paper is really going to help you. So this paper, in brief, rent control laws, they were enacted after Second World War. So after Second World War, actually, the situation was such that there was shortage of housing accommodation, and because of that shortage of housing accommodation, the landlords, they were exploiting the position, and they were just throwing away the tenants who were paying the less rent, and in return they were giving again their premises on rent on higher rent. So basically, under these circumstances, under this situation, rent control laws, they were enacted in various states. And this Delhi Rent Control Act, it was enacted basically with two main objects. Number one, to protect the tenant from eviction, and number two, to protect the tenant from paying higher rent. So there are provisions in the Rent Control Act which treating the tenant as weaker section of the society, they are protecting him from payment of higher rent. This rent controller is being given authority, the power to fix the standard rent, and once the standard rent is being fixed, after that, neither the tenant can pay higher rent nor the landlord can demand higher rent. So basically, the purpose behind Delhi Rent Control Act and other Rent Control Act, the purpose was to protect the tenant, treating him as a weaker section of the society. But after so many years, now after more than 55 or 60 years, now the situation has entirely changed. And one thing I would like to point out here regarding this Delhi Rent Control Act, that a law may be reasonable at the time when it is being enacted. But law being a dynamic concept, if it does not change in the changed circumstances, it becomes arbitrary. So that is what happened with the provisions of Delhi Rent Control Act. It was perfectly a reasonable law at the time when it was enacted, with the intention to protect the tenant from eviction or payment of higher rent. But now, because in the changed circumstances, now neither there is shortage of housing accommodation, nor the landlords are that much exploiting the tenants. So now the position has reversed. Now it is the tenant who is exploiting the provisions of Delhi Rent Control Act, because the provisions of Delhi Rent Control Act, they are more tilted in favor of the tenant. So it is very difficult for the landlord to evict the tenant. And for the purpose of eviction of the tenant, the landlord has to bring his case under Section 14 of the Rent Control Act. There are certain grounds which have been given. So in a way, Rent Control Act has interfered with the rights of the landlord which has been given to him under the general law. That is Transfer of Property Act. Under Transfer of Property Act, if the landlord does not want to continue with the relationship of landlord and tenant, he can serve a notice to the tenant, and then after that he can file a civil suit for eviction. That he cannot do in the areas where Delhi Rent Control Act is applicable, because for Delhi, if his area is under Delhi Rent Control Act, first of all, he has to bring his case under Section 14 of the Delhi Rent Control Act. Without doing that, even he is not entitled to file eviction petition. So after that, once he has been able to bring his case under a particular ground, and then even after that he has to prove the ground, then he'll be able to get that eviction decree in his favor. So there are problems with Delhi Rent Control Act. The amendment is required to be made in the act, but as amendment has not been made by the legislature, so judiciary has come forward, and judiciary on its own is declaring some of the provisions of Delhi Rent Control Act as unconstitutional. So all these things we will study in detail. So let me give you an overview what we are going to exactly discuss under this particular subject. This is not very lengthy subject. This is the syllabus is short, and the subject is also very scoring. And this subject is basically divided into 4 parts. And under this subject, basically we will study Delhi Rent Control Act, and the second one is Slum Clearance Act. And in addition to these 2 acts, also we will study some of the provisions dealing with the Transfer of Property Act. So as I told you, this act is divided into 4 parts. So the first part of your syllabus, it deals with certain provisions of Transfer of Property Act, like the definition of lease, the license, what is the tenancy by holding over, what is the relevance of notice. But obviously, because this is not the subject here, under this particular subject, we will not be studying Transfer of Property Act in detail, because that is a separate subject which already you have studied. Here, why we are referring to the provisions of Transfer of Property Act, we will study the provisions of Transfer of Property Act in relation to Delhi Rent Control Act. That what is their relevance? If we are studying lease and license, then what is the relevance of lease and license for the purpose of Delhi Rent Control Act? For example, if the agreement between the landlord and the tenant is a lease, then the tenant is protected under Delhi Rent Control Act. But if it is a license, then the tenant is not protected under Delhi Rent Control Act. So this is how we will analyze the provisions of Transfer of Property Act in view of Delhi Rent Control Act, with how much they are relevant under Delhi Rent Control Act. Requirement of notice. What is the requirement to give notice, and what is its relevance under Delhi Rent Control Act? So all these things in detail along with the case laws we will discuss in part 1. Then part 2 deal with definitions. Various definitions are being given here, that who is a tenant, who is a landlord, the very basic definitions, the very basic words which are being used throughout in the act, and also the difference between the contractual and statutory tenant, the fixation of standard rent. As I told you that the rent controller has been given power to fix the rent. And once the rent is being fixed, then neither the tenant can pay extra rent nor the landlord can demand extra rent. So this particular provision is being discussed in detail, the power of rent controller in detail, and at the same time we have judgments given by the Supreme Court and Delhi High Court where some of the provisions of fixation of rent, they have been struck down by the court as unconstitutional, because freezing of rent is not justified. Freezing of rent to 50 years back, because once the rent is being fixed, it cannot be increased. A very nominal increase is being given in the act, that is 10% after every 3 years. And we can understand that 10% after every 3 years is no increase. Like, for example, if today the tenant is paying 100 rupees per month, after a period of 3 years, he will be paying 110 rupees. So that is why these certain provisions were struck down by the court in cases. Raghunandan Saran is the main case, which we will discuss in detail. So this is the second part. Now, third part is the main part of your syllabus. Third part deal with the grounds for eviction of the tenant. There are various grounds on the basis of which the tenant can be evicted from the premises, like non-payment of rent, subletting of the premises, misuse of premises, bona fide requirement. But as I told you, in each and every case, the burden is on the landlord to bring his case under any of the ground, and then to prove his case. Only after that he may get or he is entitled to file eviction petition. So all these grounds in detail we will discuss in part 3, and these grounds, they are very important for you both ways. Like, as I told you, that this subject is going to help you in litigation also, and this subject is going to help you in competitive exams also. So this is the main area of this particular paper, from where generally the question is being asked in your competitive exams, particularly in Delhi Judicial Services. And also, if you are litigating in Delhi, then this is a portion which is really going to help you. So this is the third part, which in detail we will discuss, and this part takes the most of the time when we are discussing this particular your syllabus. Then the last part is Slum Clearance Act. Now, under Slum Clearance Act, we will discuss the power which has been given to the competent authority. Like, if your property is situated in slum area, then unless or until the permission is being given by the competent authority, the tenant cannot be evicted from the premises. So under this particular portion, we will discuss the powers of competent authority, the objective behind having Slum Clearance Act. At the same time, we will also discuss that if there is a conflict between the provisions of Delhi Rent Control Act on the one hand and Slum Clearance Act on the other hand, then which act will prevail? Whether the tenant is entitled to straight away invoke the provisions of Delhi Rent Control Act, or if he is supposed to take permission from the competent authority under Slum Clearance Act, and then he can apply for eviction. So all these things we will discuss in detail, and if you are having any doubt or any confusion, even after this webinar, you can contact me anytime. This was just a brief introduction of the subject. Thank you. Back to Shivika.
Indeed, ma'am. Thank you, ma'am, for giving a brief overview, including the beginning from the Second World War to highlighting the interesting areas of convergence and divergence between the Rent Control Law and the Transfer Property Act. I now call upon Dr. Praveen to kindly tell the students about the subject of business regulation. Over to you, sir.
Yes, good evening. Am I audible?
Yes, sir, you're audible.
Yeah.
Good evening, sir.
The subject which I have been given is business regulation. Now, regulation, if someone has to define it, then it is a sustained and focused control exercise by a public agency over activities that are valued by the community. And business regulation is the regulation of business by the state. When India became independent, and prior to that, there was a lot of state intervention. In fact, when India became independent in the first decade of that means in 50s, there were a lot of regulators. They were known as controllers. But when India adopted liberalization, privatization, and globalization, then state took the policy of regulation rather than controlling. Control means that you are not allowed to make certain things. You are not allowed to produce goods beyond a certain capacity. You are not allowed to sell a product somewhere else. So a lot of legislations were enacted. in our constitutions, every citizen under 19(1)(g) have the fundamental right to carry on trade and business. So in this course, we will discuss various cases that what is the extent of this right. This, can we say that selling liquor or selling injurious things comes within the purview of trade or not? So the doctrine of res extra commercium will also be discussed there. Then 19(6) gives the power to the state that it can control, it can regulate, it can impose reasonable restriction on the exercise of this right of the citizen to carry on trade and business. 19(6) simply says that the state can impose reasonable restriction in the interest of the general public. So it is very wide power which has been conferred on state by the constitution. Now, other than this, there is provision in the very same clause related to state monopoly. State can monopolize certain trades, particularly liquor or other noxious industries. They have actually decided not to, they are not allowing private parties to carry on those activities. Or, for example, lotteries also state regulates. So there is a lot of regulation rather than control. So in this course, our primary focus will be on certain regulators, certain regulatory areas. In this course, after the discussion of the constitutional provisions and various reasonable restrictions, we will first discuss the certain legislations which were enacted in the earlier decade of independence, like we have Essential Commodities Act, which is recently being amended, and ordinance is with the president now, and it is waiting for his approval. Then we have this another act called Industries Development and Regulation Act 1951. Under this enactment, state has the power to take over, under certain circumstances, take over the business of private entities. A company can be taken over. How it can be taken over? There are certain procedures laid down in the act itself. After this, mostly we will discuss the after 1990s legislation, where a lot of emphasis is on regulators. For example, we will discuss this SEBI, Securities Exchange Board of India, which was established in 1988, whose main purpose was to protect the interest of the investor, so that investors should not be duped by certain financial institutions. For example, you might be knowing this famous case, Sharda case or Sahara case. So we will discuss what are the powers of the SEBI to regulate the capital market and other provisions under SEBI Act. One very important feature of these regulatory institutions is that they carry out all the three functions. So in a way, there is breach of separation of power. Breach of separation power, they carry on legislative activity, they carry on executive activity, they carry on judicial activities by passing orders. You have TDSAT, you have Airport Authority of India, which is another regulator. So we will discuss SEBI. Then you have Sarfazi Act. Sarfazi Act was enacted to deal with the problem of NPA, non-performing assets. Now there is a very fast method which has been laid down in the Sarfazi Act to recover non-performing assets. So what is the procedure? How an security interest can be enforced against a person who has defaulted in payment of loan to a financial institutions. Then next important legislation is PMLA, that is Prevention of Money Laundering Act. Money laundering is is deal with basically with the crime earned from money earned from crime. So how that ill-gotten money is to be recovered. So there is elaborate procedure laid down in PMLA. Again here there are procedures like assets can be confiscated. What are the rights of the person against whom the action has been taken by the enforcement directorate. Then you have we have this another legislation called Telecom Regulatory Authority of India, which is very important regulator in India. And under this, we will see that how telecom industry is regulated in India, what are the powers of the tribe, and what are the functions of the tribe. Next area which we will discuss will be IRDA, that is insurance sector. How IRDA protects the rights of the policy holders, and how insurance sector as a whole is regulated by IRDA. These these regulators, they are mostly independent from the government. So that independence is very important. They are autonomous institutions. So all these we will discuss, we will study in this course called Business Regulation. Now, what is the importance of this course? Now, after studying this course, you have career opportunities in law firms, because there are many law firms which cater commercial needs. So then there are research organizations, then there are regulators itself. There are a lot of opportunities for law students. Then they can get internship in these regulatory institutions. Like you have TRI offers internship to the students who are doing LLB, and you have job opportunity also in these institutions. Then you have career opportunities in international institutions also, who carry out a lot of work. For example, OECD or World Bank, they have projects in which a law student can be engaged to carry out research. So broadly, this was the way we will carry on this business regulation. Thank you, Sivika.
Thank you, sir. Thank you for telling the students about different regulatory authorities they will study, such as the SEBI, the Telecom Regulatory Authority, the IRDA, and also the intersectionality with international institutions. I'm sure that would make for an interesting read for students. And now I would move on to the next presentation. The world today, in the times of COVID, has incidentally made countries react in a manner that they are moving towards more focus on domestic industries. The international trade law is the area that will answer our concerns as to how the world trade now should move across the barriers that are being created now. So for this, I would request Dr. Gurpreet Singh to please enlighten the students on the relevance and importance of the subject, international trade law. Over to you, sir.
Thank you, Sivika. My sound is audible, I hope.
Yes, sir, you're very much audible.
Okay. Give me a few moments. I'm just sharing my screen if I can do.
Right, sir.
Is it?
Yes, sir, it is visible, sir.
It is visible. Okay, thank you.
Yes, sir.
Okay. Thank you. I'm going to introduce international trade law. This is optional subject in fifth semester. What is international trade law? In fact, if you will see that the area in international trade law which we are going to cover is all those international conventions, legislations, bilateral and multilateral treaties, international Incoterms, and international organizations such as WTO. These all are the major areas which governs the modern trade. And in fact, trade is not a new kind of thing. It's a very old kind of business activities, and the traces of the trade could be located into the customary practices of the European traders who formulated certain rules for the commercial transactions. So these rules were required for the commercial transaction. For example, the rules of negotiation, contract, partnership, trademarks, and various aspects of buying and selling. So law of merchant of the European gradually spread to the entire world, and it became a basis for the trade law. Modern trade law is based on two important factors. One is free market economy, meaning thereby when we are living in a globalized world, it is contemplated that the market of every country should be free. There must be free flow of goods and services without any trade barriers. So modern international trade advocates for the free market economy. It condemns the practice of protectionism. What is the practice of protectionism is to give the protection to domestic industries and your domestic goods and services. But modern international trade law is for the free market economy. Second important principle of the modern trade international law is the principle of comparative advantage. You can understand this principle of comparative advantage by an example, and that example is simply if a state X is a good in a production of one goods and bad and average in another, and if a country Y is good in production of those goods in which the country X is bad, then X and Y they can mutually trade with each other in which they are the best. It will be beneficial for both. So principle of comparative advantage are there. Then these practices, the free market trade practices will sharpen the competition's motivation. It is for the innovations and it will bring the success, although it has certain loopholes as well. If you see your syllabus, which is available in the fifth semester, generally your syllabus begins with the GATT. GATT is a major area which has been there right from the 1947 onward, and it has held the feet of international trade law since then, till the formulation of the WTO. What was the GATT? Actually, dear friends, the birth of the GATT was totally accidental. In fact, what was being contemplated at that time when the United Nations came into existence, a similar kind of a forum was contemplated by these European countries that was known as international trade organizations. International trade organizations was not materialized because of United States Congress did not approve ITO. Therefore, the GATT, which was subsidiary kind of body, it became a prominent, and the trade has been regulated by the GATT since then till 1994 when the WTO came into existence. Dear friend, you must also make a distinguish that when the GATT in 1947, when it came into existence, it only covered the goods, not the services. But right now, the WTO, the number of activities are being covered by the WTO, like services, like intellectual property rights, so on and so forth. So, second important things which we are going to deal in your syllabus is World Trade Organizations. A major portion of your syllabus is covers the WTO. So what is the WTO? WTO is an organization. It is a multilateral forum where the country meets and negotiate the trade. So it came into existence in Uruguay round, which took place from 1986 to 1994. So in 1994, on the basis of conclusion of this round, WTO came into existence. What are the major principles of WTO? The WTO is based on free trade, idea of free trade. For this, there is principle of non-discriminations. Principle of non-discrimination is simply means that you would not discriminate between the goods of your own domestic country and goods when you are imported from some foreign countries. Therefore, you have to give them the equal treatment. The principle of national treatment is a similar kind of treatment when you regard the goods of the foreign country as the goods which are produced within your own country. So you will treat them equal treat of both of the goods. Then again, the principle of most favored nations, MFN, which you might have heard that India some years ago gave this status to the Pakistan, but Pakistan never given to us. What is this principle? Principle of more favored nations is that once you are conferring some kind of favor to one nation, then you have to treat all the other nations alike. Meaning thereby, again, this is a principle for non-discriminations. Then other part which is important under the WTO is it also talks about the subsidies and countervailing measures. What is the subsidies? You know that under a WTO there are three kind of subsidies which you can put into the three box. One is known as a green box subsidies. Green box subsidies perfectly allowable if any country or any state can give the green box subsidies to its own nationals or citizens or industries. Yellow box subsidies, which is permissible up to some extent, and then red box subsidy, which is totally prohibited. Then the last important things which WTO is going to deal in your syllabus is dumping and anti-dumping measures. So dumping is simply means when the one country tries to capture the market of another country by dumping their goods or services at a lower price. The purpose behind dumping those goods is to capture the market. Under the WTO, if one country is dumping the goods, then another country has right to adopt the anti-dumping measures. So WTO makes the provisions for these major principles. Then there are, of course, certain exceptions which has been granted to the developing country and the least developed countries under the WTO under these principles. If you see the structure of the WTO, that is also one of the topic of your syllabus. WTO, the major body of WTO is known as a ministerial conferences where the ministers of the different states meet once in a year. It is also known as a general conference. It is the topmost body of the WTO which takes the policy decision concerning to the trade, etc. Under the ministerial conference, there are three councils: council for the trade-related aspects of the intellectual property rights, council for the trade in service, council for the trade in goods. And under these three councils, there are many committees which are working in order to help these three councils. And another important aspect of the WTO is now it has a robust kind of a dispute settlement mechanism, which is known as a dispute settlement body, in which there is two stages where a dispute could be solved. One is at the panel stage. At the initial stage, when a dispute is submitted to the panels, if a state is not satisfied with the panel, then the dispute is submitted to the appellate body. So WTO has a robust mechanism of dispute settlement body. So first part of your syllabus covers GATT, WTO, and certain other aspect. Second part is more concerned about international contract in area of trade. For example, the part one under second part is about international commercial terms contract, where there are three basic terms which we are going to discuss. These are also known eco terms. For example, like cost insurance and freight, CIF, free on board, FOB, free alongside ship. When these three terms are used, these have a specific meaning in international trade law. For example, free on board. When this term is used, it means what would be the rights, what would be the duties of the buyers and sellers. Whether the buyer will bring the goods up to the boat, or from the boat there would be the responsibility of the seller. So what would be the duty of buyer and seller? These terms specifically defined. So whenever these terms are used in whatever the context, it has certain kind of meanings, certain kind of implications in international trade law. Then there is another important topic under part 2, that is payments in international trade. So here we are going to discuss two things, bill of exchange and letter of credit. When we are going to discuss all those kind of uh, method of payments, then we are also going to discuss the kinds of the bill of exchange, kinds of the letter of credit, involvement of the different banks, and what would the responsibility of the both parties. And then the last topic, which talks about the carriage of goods by sea, like bill of lading. What does it mean by the bill of lading? Kinds of bill of lading. What would be the duties and responsibilities, and how the bill of lading is created? And in last, charter parties. What does it mean by charter parties? Uh, what is the function of these charter parties? So part 2 is going to deal with this general trade contract, trade carriage of goods by the sea, payment methods. So general part is covered under the part 2 of your international trade law. What is the objective of teaching of this subject to the students? That is, international trade law devolves on the importance of trade policy as well as trade laws governing trade in goods and services across the national borders. It is a rapidly growing area in the field of international law. So it has certain objectives. That is to make the student familiar with the legal principles and concept of international trade law, to develop a critical skill among the students so that they understand and analyze international legal trade mechanism, and to critically examine important policy decisions pertaining to the World Trade Organizations and treaty negotiation outcome. These would be beneficial for the courts, tribunals, and quasi-judicial bodies, or even for the government when they are making the policies regarding the trade. So these all things we are going to cover. So thank you very much for giving me a chance to introduce this subject. Over to the Shibika.
Thank you so much, sir, for highlighting different aspects of international trade law so that students can make a rational decision as to choosing their optional subjects. As we are connecting today through online mode, the relevance and importance of information technology becomes all the more important for us. To abreast the students about this subject at the Faculty of Law, I would request Mr. Anil Sen to please talk about the option of international information technology law.
Good evening, everyone. Today I'll be talking about this paper, Information Technology Law. When we talk about information technology law, it becomes significant on us, at least in today's present times, when we actually have witnessed that even the courts became non-functional, where online and everything, when we were confined to in COVID times at our places, they were also looking for alternatives to online, offline, and other mechanisms. When I say online, there is a scenario to be understood. On these premises only, let me introduce the subject information technology law. When we talk about information technology law, over here, our current paper has been designed, which is divided into two parts. These two parts are actually giving glimpse. One, that is part A, which talks about why information technology law, what are the provisions under information technology law, how one can look for safeguards, measures under information technology law. Going on that spirit only, in the second aspect, part B, it is also providing for where all other streams where information technology law is blooming up and coming. For that reason, the paper has been designed into part A and part B. Part A talks about the introduction. When I talk about the introduction, it clearly says that why do we have this law? If you look into it, information technology law has recently, when I say recently, it is only in the year 2000 when it has come up, not before that. But whereas when you compare it with the technology existed much before the law. So what could have been the reason that we actually wanted to enact ourselves and give ourselves the law? It is very much connecting with my colleague, what he has introduced, Dr. Gurpreet Singh, international trade. While in talking about the introduction, we will certainly talk about international trade. And during the United Nations conventions, when they were talking about it, there was UNCITRAL model law on e-commerce. That is United Nations Convention on International Trade Law, UNCITRAL model law on e-commerce. That is, they wanted to talk about this model law, the genesis of which was laid down in 1986. When I say laid down, not actually found, but during the negotiation of the rounds, it was talked that we must have something because this online trading activities are on rise. Why they were on rise? Because in 1970s, the technology was found as a better means to offline modes, which was quite responsive, which was in a shorter time period, giving much better opportunities for utilization of services. So hence on that premise, 1986, it was discussed that we must have some law or some discussion so that we can talk and provide it to our member countries and they can have and plan a domestic law on e-commerce. When 1986, it was not actually given a proper shape. In 1996, it took almost 10 years where model law on e-commerce in a draft was introduced. When this model law on e-commerce was introduced, we were bound by the time frame. Hence, we had actually introduced by the year 2000 and gave ourselves information technology law. Many times when we talk about it, we do tend to use the terms presuming they are synonymous. Terms like cyberspace, terms like there is certainly a cyber field, terms like, oh, this is a virtual place. But these were not the terms which they were thought of while deciding and introducing a law governing e-commerce. Many times we also think that there is a law to deal with cyber crimes, and that is information technology law. Let me make it clear that in the information technology law was not introduced only to emphasize and deal with cyber crime or cyber offenses, but it was because of the UN resolution to provide a standard medium for e-commerce and let the e-commerce bloom up in India. It was introduced. This objective in detail will be discussed in introduction. This is all part and parcel when we talk about it, that during this introduction, there are commerce, that is business to business, business to consumer, consumer to business, consumer to consumer, and many other things in that fashion. When we go ahead looking into the entire thing, we also examine that if there is a commerce that we are talking about electronic commerce, certainly it is touching upon the contract. So we must have electronic contract as well. Electronic contract will certainly have electronic records. Electronic records must be recognized as an evidence in our domestic legislation. For that thing, we have another unit, Unit 2, which talks about legal recognition to electronic records. When you look into it, what is a legal recognition to electronic record? We needed to identify, first of all, what is an electronic record. So that we can understand electronic record and we can talk about a machine which is helping in initiating a commerce or somewhere a tool for that so that commerce can take place. We identified what is computer, what is computer network, what is computer source, so that we can actually say if these three are not involved, it is not dealing with information technology law. When we actually came up to electronic records, we identified these are zeros and ones, which are having certain significance, which have certain value. These zeros and ones must be recognized under Indian Evidence Act. Hence, for that reason, we introduced amendment in the respective law and as well as introduced enabling provision under Information Technology Act as well. Most importantly, to conclude an agreement or a contract, it is required how will you do it? Because a person giving assent or consent requires a signature. Offline, it is quite feasible with the presence of two witnesses. But online, how shall we deal with this one? The solution which was tendered was using electronic signatures. Initially, electronic signatures, they were not actually that much fruitful because integrity of the data message, authenticity, and many other issues were prevalent during that time. That is, if some image I receive, I was able to change the name of the image, change the Microsoft Word, and send it further. Hence, to deal with these issues, in 2006, digital signatures was actually talked about. These digital signatures were based on the technology-based encryption. This technology-based encryption was very popular and even in use today. When we talk about it, the technology talks about wherever you have public key infrastructure, wherever you have private key infrastructure, and these are enabled through a technical process using an algorithm, RSA algorithm or DSA 13, these algorithms, then certainly a digital signature happens. Using this private key, and public key infrastructure, digital signature was possible. So hence we will also understand, in the absence of digital signature, what is the authenticity of a record or an information or a file? Or is it mandatory for one to conclude a contract, a digital signature must be there? On these guidelines, the Unit 2 actually talks about and deliberates on kinds of e-commerce. It deliberates on digital signature. It deliberates on other liabilities which may arise as a consequence of non-use of digital signature or someone else using your signature. Hence, we have the third one, that is Unit 3, which talks about civil liabilities. Unit 3 civil liabilities, actually in today's age, not even today, if I say from the beginning of this particular law, data theft, that is when we hear Y2K bug was there, year 2000, a marking up bench during the history, we actually look into it. Why this data theft? What is the significance of data? Data having a prominent value, how we can stop and protect our data. That is why in today's time, you will not believe that even Zoom has to change and alter its perspective with respect to privacy so that they can protect the data. Many such applications and softwares fail because they do not tend to protect the data. Apple has actually promised through its hardware, that is Apple iPhone, that they will be looking after your data. For that reason only, the price of the Apple has escalated to that extent. Whereas similar configuration in another phone could be found for 10,000 and 12,000. On this basis, if we look further, data theft, then we look into a dispute resolution. Dispute resolution, first of all, amongst the domestic disputes which are arising. Secondly, where an international person or a party is involved. And secondly, it is domestic and international players are involved. Another unit which is followed by this one is criminal liability. Criminal liability, for this one, let me tell you, post-COVID or during COVID only, because COVID is still continuing, there has been 35% rise in cyber crimes. You will not believe Maharashtra police has registered more than 153 FIRs for the people who were actually looking for certain specific keywords which were offenses in India. And this particularly brings a more important domain, that what are the criminal liabilities. Under criminal liabilities, we will be talking about tampering with the data, hacking of the data, then certainly obscenity, which is more important, a growing concern, specifically in respect to the child rights. This will also be talked about. Then, since the platform is provided through an online medium and it is facilitated through a technology, it becomes essential for us to know that what is the liability of these third parties. When I say third party, I'm using a computer machine. It is, I have purchased only this machine, but the software or the application which supports transmission of data is liable for this one. Oh no, I have taken an internet service provider services. He is liable because he has allowed me to transfer a data which is offense or which is qualified as an obscene in that country. So to determine these, we will talk about how the law has come up and how these things have been interpreted by the court of law and giving the various interpretations. Internet service providers have been excused and absolved of their liabilities under Section 78, that is safe harbor principle. We will be throwing a light on that one, and then we'll talk about cyber security and cyber terrorism. That what is the cyber security? Why do we need it up? What are the consequences of these? And how to deal further? Since 90% of the functioning of each and every corporate houses has switched from offline to online cybersecurity, and rather the entire paper and understanding of this information technology law becomes prominent and most important for us. Now we have, after covering up Information Technology Act in entirety, we talk about certain international issues and certain overlapping issues which arise because of Information Technology Act. Part B deals with in that light, that is e-commerce. What is a line and how to draw a distinction between e-commerce and normal commerce? Where will the Contract Act, Indian Contract Act, be applicable, or wherever it will cease to be into effect? For that reason, it becomes essential for us to draw a line and understand the extent of Indian Contract Act and the extent of the provisions, section 11 to 13 of Information Technology Act, which talks about when the contract on online medium is concluded. Accordingly, we have another one, that is domain name. This is very much covered under intellectual property rights. But the domain name, it's quite clear, it's understandable that we find trademarks and we talk about domain names. But domain name having a significant value as like of the trademark becomes an important essence for us to understand. This has been also been part of the trademarks when you talk about IPR 1, but is specifically dealt over here by passing a reference to 2 or 3 cases which are important on domain name disputes only, which are international names as well as national names, and the dispute has arisen for them. Finally, we will be talking about jurisdiction, that what shall be the jurisdiction of information technology law or the act in India. The jurisdiction is in India only, but it extends to offenses committed outside India by a person in India. It also covers up any person outside India commits an offense which is provided under information technology law in India, and how the Indian courts over a period of time have tendered a resolution to meet the ends for both of them. So this becomes an important subject, at least in today's times, when we look and understand what are our rights, data privacy, and how to examine those. If we look into the incidents, 30% rise in the cybercrime, which is not reducing, but at par rising. Incidents like boys locker room. What is the Instagram liability? Why WhatsApp admin is liable? Why not the person who was a member or a participant of the group who has drawn and who has shared such message, which is hate message or which is obscene message, must only be liable? What are the ground realities? How one can individually protect himself or herself out of these? So this becomes an important subject in that domain where it touches upon rather each and every part which is coming up. So thank you on this note that you'll be actually enjoying this subject in that spirit. Thank you, Shivika, for this one. Over to you, Shivika.
Thank you, sir, for emphasizing on various facets of information technology law and the more controversial transnationality of the crimes that take place under information technology law and the jurisdictional aspects. With this, we come to end of today's session. It's my privilege to have been asked to propose a vote of thanks on this occasion. I, on behalf of Law Center 1 and the entire organizing team, extend a very hearty vote of thanks to all of you for making time from your commitments to grace this function and extending the honor of your presence and participation. We place on record our utmost gratitude to our professor in charge, Professor Dr. Sarajit Kaur, for this wonderful endeavor to reach out to students. Ma'am's guidance and immaculate planning is truly appreciable. I express my sincere gratitude to the knowledgeable resource persons for graciously accepting our invitation. Dr. Meena Panikar, Dr. Avikta Verma ma'am, Dr. L. Pushpakumar, Dr. Anju Sinha, Dr. Parveen, Dr. Gurpreet Singh, and Mr. Anil Sen. Your wonderful ideas, sharing of experience, and future ramifications of the optional subjects would have greatly benefited the students. We have been fortunate enough to be backed by a team of very dedicated colleagues, Dr. Anju Sinha, Ms. Archana Mishra, Mr. Anil Sen, Ms. Sachi Singh, and Dr. Kavita. We are really thankful for the sincere support throughout the program. Most importantly, the students of Law Center 1 are the backbone of this event. We recognize and appreciate the students for making time to participate in today's function. You all are truly unique and special, and that is your biggest asset. We are certain that this webinar would have given you more clarity and certainty in choosing your optional subjects. I indeed thank you all for making time to this event. Wish you a wonderful evening ahead. Take care and stay safe.
Thank you, Shivika.
Welcome, ma'am.
Thank you, Shivika.
Yes.
And thank you, everyone. Thank you all. Thank you, Sarabjit ma'am, as well.
Thank you.
Thank you all the panelists.